Well, good afternoon, everyone. My name is Jenny Wigley, and I'm here with my colleague, Luke Wilcox. Just before we start, to avoid background disturbance, please could I ask you to ensure that your microphones are muted throughout. They should be automatically muted at the beginning anyway. And as for questions, we're very happy to answer questions. If you have any, if you could put them through the chat function at the bottom of the screen, and we'll endeavour to answer them as we go through or at the end if we have time. So this webinar is about the COVID-19 restrictions and their effect on rates. And of course, those restrictions have been ongoing now for more than 10 weeks and have had a huge impact on the use of non-domestic property. As we all know, hospitality, leisure, retail, or at least most retail, have been effectively required to close their premises completely. And as a result, government has announced that they should get 100% rates relief for the entirety of this financial year. And interestingly, the way that relief is being implemented is not through a legislative change, but by guidance issued to billing authorities directing them to effectively use their discretionary powers under Section 47 of the 1988 Act to grant the relief in accordance with the government criteria, on the understanding that the government will then reimburse them for that relief granted. And it remains to be seen exactly how that will operate and the criteria that will be set by the local authorities, because there is some grey areas in relation to that. Additionally, other occupiers including some office type occupiers who have entirely vacated their premises due to the working at home restrictions, should, in my view at least, be entitled to empty property relief for the initial 3 month period. And there may well be disputes arising out of that. And I understand that billing authorities are currently at least taking quite a hard line in relation to that. So that's another area to watch. But the issue we're going to focus on today is whether and how the effects of the coronavirus crisis, and particularly the restrictions, whether and how those amount to material changes of circumstance that entitle a ratepayer to a reduction in rateable value. It's a matter that's been occupying at least some of us for quite a while now. And so we thought it would be useful to provide an update on the position and discuss some potential pitfalls and tips, hence the title of the talk. We intend to do this by way of an informal discussion between the two of us, structured by reference to 5 main questions, which we'll go through in turn. So, without further ado, the first one for Luke. Luke, tell us what the up-to-date position is and what developments do we need to be aware of in relation to COVID-19 and NCCs.
Thanks very much, Jenny. Good afternoon, everyone. There are 2 key updates that I'd like to focus on with you. And what I'm going to do, if my technological skills are up to it, is pop them on screen one after the other. The first thing that we need to be aware of is guidance, which was issued by the Valuation Office around about 2 weeks ago. You won't be able to see it on screen, but this has come from Alan Colston, who will be known to many of you, a very senior figure at the VOA. And what this guidance gives us is essentially 4 points. Rather than reading it out, I'm going to take you through the 4 key things you need to be aware of. First of all, multiple proposals can be made off the back of a single cheque. It's a point that's clearly right, relatively uncontroversial. Secondly, and this is an important point, although it's helpful for you as the ratepayer to identify in your cheque documentation the grounds on which you're seeking an alteration of the list, there's no actual requirement for such specificity in the regulations. The cheque process is designed to check all of the relevant information, not just information in respect of a particular ground. That can open up the possibility of looking at multiple lines of COVID-19 related potential alterations through one check, although there are some subtleties around that we need to deal with. Thirdly, and this is where things get a little more controversial, The VO says in its guidance that the COVID-19 crisis is likely to give rise to external MCCs rather than internal ones. The two types of external MCC, of course, being matters affecting the physical state of the locality or physically manifest in the locality on the one hand, and on the other hand, matters, well, not even matters affecting, but changes to the use or occupation of other property in the locality. So those are the areas where the VO is expecting these matters to be focused. Finally, the VO has emphasised that there's no need for multiple checks. And you can see that on bullet point number 3 on what's on screen there. The idea is that you can make multiple proposals off the back of a single check, so you don't need to do several. So that's the first of the things which has happened in recent weeks, which you need to be aware of, the VO's guidance. The second matter which you need to be aware of relates to a change in the legislation. And this change came into effect earlier this week, on Monday, in fact. Now, we'll all be familiar with the lockdown rules which applied, certainly the lockdown guidance and the way the rules have been publicly presented until earlier on this week. In effect, what those regulations provided, in as far as it's relevant today, is that you weren't allowed to leave your home without a reasonable excuse. And the reasonable excuse which is relevant for us included the need to travel for the purposes of work, if it's not reasonably possible for that person to work from where they're living. So if you can work from home, you have to work from home. If you couldn't work from home, you're allowed to leave and go to work. As of Monday of this week, the position has changed. I'll see if I can get that on the screen in one go. I'm not going to be able to, so I'll scroll down. What we have under the new regulations is a two-tier approach to this issue. First of all, you're not allowed to stay overnight anywhere other than where you're living. Again, there's a reasonable excuse mechanism there, which includes if you need to stay away from home for work purposes.
Luke, sorry, there's a little bit of interference. I think you might need to just step back away from the microphone a little bit. There's slight feedback. I don't know whether it's anyone else is hearing it, but just. Okay.
Well, I'll try sitting back a little bit. I'll see if that helps. Okay. Thanks, Jenny. Sorry, everyone. Going on to the second sort of limb of the new regulatory changes. This is the new Regulation 7, and that deals with gatherings. So you are not allowed to have a gathering. Oddly, it's defined as a gathering indoors consisting of 2 or more persons. A slightly strange way of putting it. Unless, again, it's reasonably necessary, amongst other things, for work purposes. A gathering, as you can see there, is 2 or more people present together in one place, either for social interaction or to undertake any other activity. Quite how that fits with people going into an office to work is unclear. It's certainly an argument that if you're going into work to sit in your cubicles next to one another and work, then you're neither undertaking an activity with each other or gathering for the purposes of social interaction. But in any case, that's another, I think, really important change in the position, which will affect in particular how internal MCCs are going to manifest. Now, Jenny, do you want to tell us what you think are some of the implications of these two changes?
Yeah, thanks, Luke. It's quite interesting looking, first of all, at the VO's guidance, and particularly this point about it's not necessary to submit multiple checks. And of course, that's right, as you said, in the sense that you can make multiple proposals on the back of a single check. But it's important, I think, to bear in mind, particularly in the fact that this is a movable feast and a changing picture, as you've demonstrated by the change in the legislation, that then there will of course be a need to submit further checks if you need to reset the material day, because the material day of course is set by reference to the check and the receipt of the information related to the check. So for example, at the moment the restrictions are on the loosening trend, but it may well be that they become more restrictive again if there's a second spike or or for whatever reason. And it's important to keep an eye on that, and to, I think, to consider making further checks if you need to reset the material day. So that was one point that occurred to me. Another point is that guidance does give quite an important insight, I think, as you mentioned, Luke, into how the VO are viewing the likely categories of MCCs that COVID-19 is going to give rise to. And they do, the VO does appear to, at the moment, not really have much regard to the possibility of a ground A, paragraph A type change, i.e. an internal change, which, I think, you and I have discussed before, it quite clearly, we think, arises from this restriction to home working, particularly the regulations as they stood previously, which effectively prevented the enjoyment of office space, in the sense that it was illegal for many office workers to actually go to the office. So it does appear to be the case at the moment that the VO is overlooking that aspect, or at least not putting it front and centre in the changes they're considering. So I think that's sort of the update where we've got to. Just mentioning ground A and you mentioning ground D and E, I wonder whether, just before we move on to the second topic, the second question, it might be useful to have the legislative framework up on the screen, the backgrounds framework to MCCs. Can you do that? That's great. And just while you're doing that, Luke, we all know, of course, that the MCCs are defined in the statute. And you can see there now on the screen, thanks Luke, that the matters that constitute MCCs are defined to be a change in any of the matters mentioned in paragraph 2.7 of Schedule 6, and that's it, just above in paragraph 2 there. And those matters are listed in our paragraph 3, and as we said, include A, which is matters affecting the physical state or physical enjoyment of the hereditament, and then D and E, which you mentioned earlier, Luke, and also the additional possibility of a change in the mode or category of occupation of the hereditament. So those are the kind of defined change in matters to constitute an MCC. And so to get through the gateway to achieving a reduction in rateable value due to an MCC, you have to first establish that the change you're looking at, the change in circumstance you're looking at, falls squarely within the wording of one or more of those paragraphs, those subparagraphs. But that's not the end of the matter. Then to establish the ground of challenge under Regulation 4.1b, which is, I think, is at the top of that sheet, Luke, if you just scroll up, which is of the 2009 regulations. Yes, the highlighted text there. The rateable value, it has to be shown to be inaccurate by reason of the material change of circumstance. So there has to be a causation between the MCC identified fitting in with A, B, D or E, and that causing a value significant effect. So there's those sort of gateway hurdles you need to get through before you can achieve a reduction in rateable value. And it's important, I think, to look at that legislative framework, particularly by reference to this current coronavirus crisis, which is unprecedented and which, of course, potentially gives rise to a whole myriad of different effects and different potential MCCs, and to take care to ensure that the MCCs that are relied on fit within that legislative framework. So moving on to our next topic, Luke, against that background, in terms of drafting the proposal document and framing it within the legislation, how important do you think it is to ensure that each and every possible or potential COVID-related effect is included in the proposal?
Thanks, Jenny. I think if I had to answer that in a single sentence, I'd say it's important, but it's not necessarily critical in every case. And the reason I put it that way is because of a principle that emanates from an authority called Reed Pierce, which some of you may have heard about. Michael Pierce being a valuation officer in the VOA, who was the appellant in that case. Reed Pierce, it was a case about White Walton Aerodrome out in the west of London. And what happened was that a valuation tribunal determined an appeal against the RV of the aerodrome, but it did so using the wrong floor area, the wrong size. And subsequently an MCC proposal made because some other buildings by the aerodrome were removed. And a question arose about whether or not in the MCC valuation, it was open to the VO and the tribunals to correct the error in the floor area, or whether they were restricted to changing the previous RV to reflect the effect of the MCC, if I can put it that way. And the answer was that when the VO or the tribunals are carrying out an MCC valuation, they have to do what's called a single unified valuation, to use the language from Pierce. In effect, if you get through what Jen has called the gateway, if you've established that you have an MCC and that that MCC has caused the RV of the property to be inaccurate to any degree, then you have a valid proposal which triggers the revaluation of the property as a single unified act, taking the material day factors to be as they are for the material day for the MCC and the proposal, but picking up any other relevant factor at the material day, which was in existence, whether it's mentioned in the proposal or not. So by way of an example, if you have a building and you've got two occupied shops on either side of it, and both of those shops become unoccupied, you make a proposal on ground E saying, you know, change in the use or occupation of premises in the locality for one of those neighbouring properties, and you establish that your RV should go down because of it. You've got a valid proposal. The valuation which is going to take place has to reflect the vacancy of both units. So once you're through the gateway, you look at all the facts which apply at the material day. What that means in the context of coronavirus is that if you manage to get yourself a valid proposal, relying on the regulations, say, for a change in matters affecting the physical enjoyment of your property, it's illegal for your employees to go in. And at the same material day, there had also been a change in the railway network, and there were very few trains coming through or something like that. The impact of the train closure being a matter physically manifest in the locality can be pulled into the valuation as well. So in that sense, Pierce gives you a really helpful way of mitigating some of the problems that might otherwise arise if your proposal's on narrower grounds. Now, I don't want to overstate how far you can take this principle. It's important to bear in mind that the effective date of your change is going to be fixed by the MCC, which is in the proposal. So if there are other value relevant factors, which on their own would have had an effective date way back in time, much before that, and things like the closure of restaurants in the area and so on will often have taken place before the regulations came into force, you won't be able to get the full effect of the reduction that you'd otherwise be entitled to for those changes if you haven't specified them within your proposal. Jenny, I know you wanted to comment on this as well.
Yeah, I think that's right. I think it's a really helpful potential like safety net, effectively, if you miss something in your proposal, that hopefully, you know, as long as your proposal is valid, you can bring those other things in, as assuming, as you say, the dates work. But just a word of caution on that is, of course, in these sort of uncertain times, and this all being a little bit new, not having the VO not having dealt with this type of thing before, I would say that to be safe, it would be sensible to put in all of the potential MCCs that have the same effective date and same material day that you can, because you don't want to risk relying on one that you think is going to be a gateway event, and then for whatever reason it fails, because either because it doesn't fall within one of the subparagraphs, or because it's found not to be value significant and so not cause the rateable value to be inaccurate. If that one doesn't cause it, but you've got other ones that do, I think you're still going to fall down, because you won't be able to bring that in because you won't have the valid ground under 41B. So I think the Pierce principle is really helpful, but use it as a fail-safe rather than relying on it from the outset, I think, is the answer. Okay, well, that's really useful. Perhaps we should go on to question 3 now, Luke, which is this point about there being different time limits for that apply for getting in the proposal or the challenge and the supporting evidence. And those different time limits depend on which ground under which subparagraph under 2.7 you're relying on, and that was mentioned in the VOA guidance that you referred to earlier. So for internal or kind of paragraph A events, it's 4 months from the completion of the check, but for D&E type external matters, it's 16 months. So you have longer potentially from confirmation of the check information. Now, as I said, the VOA guidance that we looked at recognises that fact in itself, but is silent as to what would be the position where you have a proposal relying on a number of different subparagraphs of 2.7, so relying on both internal and external. And so in that circumstance, how does perhaps the principle in Re Pierce help in enabling a ratepayer to rely on the longer time limit when having a proposal that includes both the internal and external? Do you want to just say a little bit about that, Luke?
Yeah, of course, happy to. The short answer to that is that if you've got an internal and an external MCC, which are both manifesting your property at the same material day, then the Re Pierce principle means that if you make a proposal on the external MCC, and you get through the various gateways that Jen has described, that's a critical caveat we have to keep coming back to. If you get through those gateways, then you're able to take advantage of the longer time limit for an external MCC and take advantage of the 16 months to get your proposal in. But the internal MCC is going to be wrapped up in the valuation as simply another factor which exists at the material day. That's a way in which it can be used helpfully to enable you to get more time to get your challenge in if you think that you're going to need it. There are a number of difficulties and risks around the operation of Regulation 6A, which is where all this comes from. It's Reg 6A of the Alteration Lists and Appeals Regulations as they apply to check, challenge, appeal. This is a regulation, the operation of which is currently untested by the courts and tribunals. So whatever we say about this has to be approached with a little bit of caution. There are 2 ways of reading the 16-month availability provision if you've got a proposal that has an internal and an external MCC in it. One of them is that the proposal raises an external MCC, therefore you get the 16 months and you get to bring through the internal MCC grounds into your challenge with it. If it includes an external MCC, then you get the external MCC time limit. The other way it may work is that you get the extended time limit if your proposal only includes an external MCC. Now that introduces an element of risk here, because if you have a proposal that raises 2 MCCs, one internal, one external, and you wait 16 months to put your proposal in, it may be that the effect is to make the whole thing invalid. And that would seem a fairly stark consequence, but it's not one that can be ruled out. So it's something that when you're structuring your proposals, you have to bear in mind. It may be that in practice, these issues are less urgent than they might otherwise be because of the way that the Covid-19 type MCCs have arisen. If you look at Regulation 6A subsection 4, that tells you can only have more than one MCC on a proposal if the material day and the effective date of those MCCs are identical. Now, the kind of things which give rise to internal MCCs in this context are going to be things like the issuing of guidance and more probably changes in legislation. The sort of things that are going to be external MCCs are going to be things like cafes closing in anticipation of lockdown, or the train timetable being reduced following the lockdown or something like that. It may well be, when you analyse it, that the internal and external MCCs have different effective dates taken individually. And if that's the case, they would have to be on 2 separate proposals anyway. So whilst this sounds like it's an area with a lot of risk in it, I think it's going to be possible, indeed likely in a lot of cases, that that's simply not going to manifest because you can't wrap them all up in one proposal anyway. Final word of warning on Regulation 6A before we move on, which relates to the final provision of it, says this is an area where you can't make multiple checks. If in the course of a check you provide information or confirm information relevant to an MCC, then you have to make a proposal, if you're going to, within whichever the time limits applies from that check. What you can't do is check the information on one check, then put another check in 6 months down the line and seek to use that second check to provide the trigger for a subsequent proposal. Regulation 6A prevents that from happening where you're talking about MCC proposals of any kind, internal and external. So in effect, you have a once and for all position on the check for any given MCC that may arise. Of course, if the position's changed, you'll need further checks, as Jenny said. But it's worth bearing that in mind as well.
Yeah.
You can't do what you could normally do.
Yeah, as you say, Luke, if the position changes, even in relation to the same type of event, so for example, a home working, or if the change in the degree of strength of the restrictions changes, presumably then you would be able to do another check because you'd need another material day to assess it by reference to a changed position.
Absolutely, I completely agree with that. Yeah, if the change in the regulations, for instance, is probably a second MCC. Yeah,
exactly. Yeah. Okay. Well, that's useful then. And just on that, just before we move on, how important do you think it is to get the effective date right? Now, Regulation 6.4, I think it is, says that you have to include in the proposal the date from which the proposer asserts the proposed alteration should have effect. Now, to my mind, that means that you have to have a stab at what the effective date is, but you don't necessarily, if you get it wrong, it doesn't necessarily invalidate your proposal. What are your thoughts? Any different to that, or what do you think?
Well, this is a really interesting area. If you'd asked me that question 6 months ago, I'd have said that there was very little risk to the validity of your proposal from getting your effective date wrong. But there's what I suspect may have been a throwaway, but potentially quite important comment from the upper tribunal in a case called Colour Weddings, which came out, I think, either at the tail end of last year or earlier this year. Colour Weddings was a 2010 list appeal. And one of the things that happened there was that the effective date specified by the proposer turned out not to be the correct effective date for the list alteration in question. It was a monk type case, and they went before the scheme had really got going. And one of the arguments the VO advanced was that the proposal was not valid, or well, more specifically, that the proposal was fixed to looking at the effective date that the ratepayer had asked for, when there was no justification for an alteration. The tribunal said, no, that's not how it works. Because the regulations don't require you to specify the effective date, you can apply whatever effective date the evidence shows to be correct. Now, for the 2010 list regulations, that's correct. As Jenny said, under the 2017 list, Regulation 6 now does require you to specify the date from which you want the alteration to have effect. And there is, at the very least, a risk that the tribunal is going to hold you to that specified date in deciding whether or not you've made good your proposal. So if your effective date is a week before it should have been, previously the tribunal would just move it a week later. That may not be available anymore. Unclear how that's going to work. It's not clear whether it's going to be applied that rigorously. But at the very least, we need to do more to get our effective dates as accurate as we can in our proposals from now on.
Yeah, I think there's still a strong argument that, you know, as long as you put one in and assert something, you've met the requirement, and then the evidence can fall out and show what the actual date is, as long as you made a reasonable stab at it. But I agree, it's clearly a risk. Okay, we better move on because we're running through the time quite quickly. Question 4, we're looking a little bit more detail now at the at the paragraphs, the sub-paragraphs of 2.7 and the grounds that we have to fit within to make out an MCC, what do you want to just talk a little bit about what you think the important differences are between, for example, particularly paragraph A and paragraph D, other than the obvious point that paragraph A relates to the hereditament and paragraph D relates to the locality? And in asking that question, it's really how restrictive or unrestrictive those are in relation to trying to get your event within them. What do you think about that, Luke?
Thanks, Jenny. This is a subject we could spend all day on, and in particular, in respect of paragraph D, what is, in my view, some of the most difficult and confusing case law in recent times in rating has emerged around how paragraph D works. I know Jen has been involved in some of those cases in the upper tribunal, so she's well aware of some of the complexities that can arise. The key difference, you can see on your screen there, we've got what the matters are, and there are 4 we need to talk about. The advantage of paragraph A, which is physical state or physical enjoyment, is that the matter that you say is the MCC only has to affect the physical state or the physical enjoyment in order to be within the paragraph. It doesn't, the matter doesn't have to be itself physically manifest or anything like that. You don't have to be able to look at what's changed and say, aha, that must be because of this thing. You just have to be able to say that the matter has affected the physical enjoyment. Now, in the context of coronavirus and COVID-19, I suppose I should say, the matter affecting physical enjoyment may well turn out to be the regulatory restrictions. If your employees aren't allowed to go to the office because they're capable of working from home, then you're not going to be physically present in your property. And an inability to be physically present in property through employees is recognised by the VO in the rating manual as being a matter affecting physical enjoyment. A classic example of this is something like the smoking ban. You know, you could see the massive drop in attendance at something like a pub or a bingo hall as a result of the smoking ban. You may not be able to know it's the smoking ban that's caused it, but it's enough that the matter's affected it in that way. So that's a very broad definition, it seems to me. The word affecting allows quite a lot of leeway in what can and can't come in. It's relatively, I perhaps cursing myself by saying this, but relatively uncomplicated to understand and apply. Paragraph B doesn't even have the words matters affecting. It's simply a change in mode or category of occupation. Now, of course, as we all know, mode or category of occupation is a broad context. A shop, but no particular kind of a shop, is the classic formulation from an old case called Fir Mill, which the Court of Appeal endorsed. It's of the 4 of them, it's the one which may be least relevant to COVID-19 and the situation we find ourselves in. But in some cases, I can envisage situations whereby, say you have an office and none of your employees can go, and you apply to the billing authority for empty rate relief, and they say, no, you're not having it, your office isn't empty, you're storing documents there, or something like that. I can envisage circumstances where you might be able to argue that in that situation, there's been a change in the mode or category of occupation of the premises. It's no longer any type of office, it's become a store. And a store or a warehouse may have considerably lower RV. So I think it's going to be the rarest to come up in practice, but we can't rule out the relevance of paragraph B in this context. Subparagraph D, physical state of the locality. This is where things get really knotty and get really complicated in the case law. A matter affecting the physical state of the locality would be something like building a new school across from your shop, say. You know, something which has happened to the bricks and mortar and the land which is there in the locality, permanent physical change, not too difficult. Where it gets really tricky, and this is the part that's given rise to difficult case law recently, is the second limb, which is a matter which, though not affecting the physical state of the locality, is nonetheless physically manifest there. Now, this requirement for the matter itself to be physically manifest has thrown up all kinds of problems. There are 4 or 5 cases that have looked at it. Probably the 2 most important are the Merlin Entertainment case about Alton Towers, where it was said that a change in public attitude to risk in theme parks following a big crash and an Alton Towers ride was a matter within this paragraph, and the tribunal said that that wasn't right. And the second one is a case about Wigan Football Club, the Wigan case, which Jenny knows far more about than I do, where again they had to consider how paragraph D worked in some detail. It seems to me there are going to be a number of COVID-19 related alterations which might come within paragraph D. If, for instance, you could say that the value of your property has gone down because the train timetable has gone from being a train every 90 seconds rocketing in on the Bakerloo line to a train every half an hour or something like that. A change in the train timetable is not a change in the physical state of the locality. There's nothing happened to the rails or the platforms or building that's changed. But that change is itself physically manifest. It's something that you could go and see with your own eyes and hear with your own ears because there's far fewer trains coming through. So the problem with, the challenge, I should say, with paragraph D is identifying with sufficient precision what you say the matter is, which is itself physically manifest. Final one, of course, we've got here is paragraph E, use or occupation of other premises in the locality. This is different both from the internal MCC provisions about physical state and from the state of the locality one we've just talked about, in that you don't need any sort of matter affecting, you don't need any physically manifest, anything like that. All you need is a change in use or a change in occupation. These will capture much smaller changes than you could get from mode or category of occupation. A shop, or no particular kind of a shop, for instance, a change from a food store to a hardware store wouldn't be a change in mode or category of occupation, but it would be a change in use. So something which wouldn't be an MCC in your own hereditament may well be an MCC in the hereditament next door. Similarly, it's not an MCC if your own hereditament becomes empty because it's assumed to be vacant and to let for rate and valuation purposes. But if COVID-19 has caused every single cafe in a mile radius of your office to have closed, that's a change in the occupation of premises in the locality. If it's going to reduce the value of your office because your employees have got nowhere to go and get their lunch, and so there's some kind of impact in that way, then that sort of change can be pulled in under subparagraph E as well. Now, one of the issues which comes up all the time with the trickiest of these 4, which is subparagraph D, is about matters affecting the physical state of the locality, and a concept which the courts for about 10 years or so have called masking. Now, since Jenny was in the Wigan case, she's intimately familiar with this concept. Jenny, do you want to talk us through what masking is and how it may or may not be relevant for COVID-19?
Yes, of course, Luke. I mean, I think that the fundamental problem and difficulty behind this physically manifest point is that quite often it's the intangible matter behind a physical manifestation that is value significant. It's not necessarily the physical manifestation itself that is value significant. And you've got those 2 links, which Merlin, David Holgate and Merlin effectively said you can't make those 2 jumps. You have to have something that is itself physically manifest, and then that itself has to be value significant. And whether something is physically manifest itself depends on how direct its effect is on the local area. So, for example, in the Ree Kendrick case, which concerned the executive lounges in Heathrow and the effects on attitudes of people travelling following 9/11, there was some reduction in passenger movements through the airport and through those lounges. But there are also a myriad of other effects potentially causing that, including the general economic downturn and lots of other effects. And it was held there that the effect of the attitudes of people fearing to travel was masked and was not manifest because it was masked by other potential factors. In my case that I did, the Wigan case, one small win I did get, which obviously didn't win out in the end, but was that the change in league status, so the relegation of the football club and the change in league status, we argued had a physical manifestation in the area by the lower attendances and the lower activity on match days going to and from the stadium. And the upper tribunal effectively accepted that, or did accept that, and rejected any argument as to masking in relation to that, said it would be obvious that would be the effect. And the reason we failed was on other grounds. But similarly, I think in relation to COVID-19, because the changes and the restrictions are so stark and are so sort of shockingly different from what went before, I think the link between those effects and the physical manifestations of those effects and their cause will be so direct that I think it would be, I think you would have strong arguments against a masking type rebuttal from the VO. I think you'd be able to say, look, if you saw the streets on the 23rd of March or the 25th of March and compared them to the 12th of March, it was absolutely obvious that something very clear had happened, and that was a physical manifestation of the COVID-19 effects, and not masked by just general fluctuations in people's work patterns or general fluctuations in weather or whatever. So I think that ground D is tricky because of this double link. You have the matter, you have to be physically manifest, then it has to be value significant. But in relation to COVID-19, because the effects are so stark, I think that the problem should be less than they might otherwise be. So those are my musings on that. Perhaps we should move on now to question 5, Luke, which is sort of trying to stand back a little bit from the legal technicalities, and how do we consider the effects on value? And obviously that's neither of our direct expertise, but it's this common sort of mantra, isn't it, that economic matters and demand have to be taken as they are at the AVD. You can't consider economic matters at the material day. But just digging into that a little bit deeper, is that strictly correct? And surely we're able to carry back material day matters that have economic effects back to the AVD and see how they would affect demand, for example. And it's perhaps too simplistic to say that, economic is AVD, physical is material day, demand is AVD, and supply, for example, is material day, which I think is what some people assume as a sort of shorthand way of looking at it. What are your thoughts on how these things translate into value significant events, and how you can influence the economic situation at the AVD by what we're kind of using as MCCs at the material day?
Thanks, Jenny, and what a question to unpack.
I thought we'd end
we could have a week's worth of seminars on that issue, but boiling it down to or maybe a nutshell for all of that, the idea that economic factors are AVD and physical factors are material day is the sort of thing which is a helpful shorthand.
Yeah.
But as with most helpful shorthands, there are going to be occasions where it might mislead or it may cause problems. And the events around COVID-19 in some ways provide, it seems to me, a really good example of how they might be problematic. That's because the only reason that any change in material day factors it gives rise to a list alteration is because it has caused the RV to be inaccurate. And as we all know, the RV is based ultimately on the higgling of the market. The RV is about what the hypothetical landlord and the hypothetical tenant will agree between themselves should be the value of this property. And that is ultimately an economic question. If your property, for instance, at the material day is closed, your employees can't go to it because it's crime for them to do so because of the COVID-19 regulations that came into effect on the 26th of March. If that's the position you're in, then that is a factor. It's a matter affecting physical enjoyment. So we take it at material day. You can't simply say what would have happened in the economics at the AVD back in 2015 for that factor, without pulling the economic implications of that factor back to 2015. And that becomes even more problematic when you recognise that for a lot of classes of property, the higgling of the market is going to be mostly impacted by the availability and the state and the market of other premises in the locality. And if you are in a position where every other property in the locality is empty because of the same regulations, then even though in 2015 you may have X set of economic conditions, the way those economic conditions will play out in a hypothetical valuation is going to be massively altered by the fact that your property can't realistically be used and nothing in the area is occupied either. It's going to put the landlord in a dramatically weaker position than it otherwise would have been in, because you could say, well, a hypothetical tenant could go to any of these other premises in the locality, and for the purposes of this class of property, the locality is the whole relevant market. So in that sort of situation, the economic sort of macro market state at the AVD may be of very little relevance. It may be that the whole structure of the valuation is actually shaped by material day factors. Similarly, notions of supply and demand work in a similar way. The idea that demand is fixed at the AVD and supply is fixed at the material day is a useful shorthand. But what if the demand for your property, which said by that little maxim to be an AVD factor, is entirely wiped out by material day factors, as would happen if Covid-19 regulations have what we suspect is going to be the valuation implication of making no tenants want these things. In that case, you've got a big impact on the assumed demand for valuation purposes at the AVD from factors which arose in the material day. So if there's one piece of guidance I can give you about how to make sense of all of this, which is a pretty complicated area, is that the starting point has to be the statute. Has to be the statute. If something is within paragraph 2.7 of Schedule 6, which is the paragraph 3 you can see on screen, so if it's physical state, physical enjoyment, mode or category of occupation, any of those things, take it a material day. You take everything else as it was at the AVD, which will include a lot of economic factors, but not necessarily all of them. You take all of those various factors from the two dates, put them into the blender, and see how the market would higgle for those factors in that way. And that is, in effect, what the rating hypothesis requires you as valuers to do. It's not quite as simple, I think, as to say economic at one date, physical at another.
I agree, Luke, and I agree completely with your guidance about going back to the statute, because it's quite clear that there's no reference to the word economic and AVD in the statute. The AVD just captures everything that's not in paragraph 2.7, and not everything in 2.7 is physical either. So, you know, mode or category of occupation, for example, is not a physical matter anyway. So that shorthand really can be quite misleading, and I think you have to be a bit wary of taking it at face value and making sure you unpick it, don't you, when you're analysing these sorts of problems. So yeah, and as you say, we could go on forever, but we're not going to. Just one, before we get on to the question, just one final point on valuation, which is this point about clearly well, we all hope and pray, if we're that way inclined, that the COVID-related restrictions are temporary, and that eventually we'll go back to normal. And in light of that, how does that affect, how does that transience of these restrictions affect value? How does that play into what a tenant looks at when the hypothetical tenant is making his bid? Does he or she factor in the fact that by their nature these sort of restrictions are likely to be temporary? Or on the other hand, do you just say, well, these are the facts at the material day, they apply, you take those as they are at the material day, the value is their direct effect, irrespective of how long they last. And the way you factor in how long they last is by limiting the reduction in RV for that period. What's your kind of musings on which approach is correct? And there's not a clear answer, I think, is the answer.
I think that's right. And Jenny, I know you and I have spent hours on the phone over the last 2 months battling backwards and forwards on this issue. It's tremendously interesting. And helpfully, it also is one of the questions we've been asked, so we can seamlessly blend
okay.
as we discuss this issue. The answer, in as far as I can give one, is that there are cases pulling in both directions here. There are a number, I'm aware of, sort of 7 or 8 lands tribunal cases under the General Rate Act, which touch on this issue of valuation transients. And some of them say that you can reflect the anticipated short-term nature of an MCC in the higgling of the market. Others say that you can't. You have to take the material day factors as they are and go no further than that. This is an issue which hasn't really been argued out yet under the 1988 Act. But there are a couple of cases that touch on it and give some quite tantalising steers about how this might play out. The one I want to talk about, and the one which is potentially the most helpful guide, is Williams against Scottish and Newcastle, which many of you will be aware of. This is the case which gives us the shop, but no particular kind of a shop, formation about what mode or category of occupation means. At least it's Court of Appeal endorsement for that way of putting it. But the actual issue in Scottish and Newcastle, it was about a couple of premises where in effect they were at the material day being used as pubs, but they had planning permission for use as shops. They hadn't yet been turned into shops, but it was permitted for them to do so. Their value would have gone up by an order of magnitude if they were shops rather than pubs. And the capital outlay that you would have required to convert them from pubs into shops was relatively modest. In other words, in the real world, a tenant coming to these premises would obviously reflect its development potential as a shop. The issue is whether that development potential could be reflected in the rating valuation. And the answer was no, it couldn't be, because the mode or category of occupation of the hereditament is fixed at the material day. And at the material day, it hadn't yet changed to be a shop, which means you have to put out of your mind its development potential. If and when it actually changes mode or category of occupation and becomes a shop, then that is an MCC which will trigger a revaluation. It's going to go up massively, so it'll probably be by VON, but that doesn't really matter. It's still a factor which justifies a list alteration. But unless and until the event occurs, you don't reflect its potential in the valuation. So that's what Scottish and Newcastle says about it. There's another case, though, which suggests something slightly different, which is a case called Repavlu. And I know that this is one which Jenny and I have spoken about. Jenny, do you want to deal with Repavlu, or would you like me to?
Yeah, sure, Luke. Yeah, Repavlu was a case about I think it was a restaurant on Paternoster Square, which was affected by the Occupy London protests in, I think it was 2011. And if you can recall, there were lots of tents and everything all in front of St Paul's, and there was closures of certain areas and routes around Paternoster Square, which had a severe effect on footfall and a severe effect on customers coming into the restaurant in question. And so the question was how that is a material change of circumstance, clearly manifest in the locality. But how do you value that? First of all, there was a question, is it just too transient at all to take into account? The tribunal found, no, it's not too transient. And anyway, from my point of view, transience, it clearly isn't an established test for value significant events. That's a test for occupation. But no, it wasn't too transient. And it wasn't similar to, I think, an old case where someone was saying that the road that in their new housing estate hadn't been properly made up, so it was too icy to drive up for a few days, and that was found to be just the normal run of things and couldn't be an MCC. That was one of the old cases I think you were referring to just then. But in Re Pavlou, the way this translated into value and into reduction in RV was to sort of try and work out what the hypothetical tenant at the appropriate date would have thought about how long the protest would last, and what they would have kind of seen from the protests in other capital cities, and how likely it was that was going to go on for months or weeks or whatever. And it was by reference to that estimation that the value was set and reduced by 25% or whatever it was. So there, a very different approach was taken. But it has to be said that, you know, the argument you just laid out, Luke, in relation to Scottish and Newcastle, certainly wasn't put forward in that case. And I think there's real scope for a real fight on those two different approaches. I mean, on the one hand, you could say that these types of restrictions are inherently temporary. So whilst you take them at the material day, you also take the inherent temporary nature of them at the immaterial day, and that could be a way of distinguishing Scottish and Newcastle. But on the other hand, the statute's very clear: you take the matters as they are assumed to be at the material day, in which case you don't allow for the changes that might happen, like the mending, or like in your case the conversion to the office pursuant to the existing planning permission. Conversion to a shop pursuant to the existing planning permission in Scottish and Newcastle. So I think it's quite an open area for ripe for some argument and some cases and instructions, actually, don't you, Luke?
I couldn't agree more, Jenny. This is the sort of point that's got the Court of Appeal written all over it, I think.
Yeah, exactly. So on that note, we better move on quickly to some of the questions, and I'm handing over to you to sort of take charge here, Luke. I haven't had a chance to look through many. Have you got any I
have. I've got a few, Jenny, and we'll try to. I'll try to make sure we both deal with some of them. I won't hog them all. Here's one. Here's one you might want to take.
Difficult one. Okay.
I'll hog the difficult ones. Here's one you might want to take, Jenny. It's a question about a change, an MCC, which is a physical enjoyment factor, where the valuation impact of the factor continues after the factor has ended in the real world. So by way of example, you've got the Covid-19 restrictions. It's a matter affecting physical enjoyment. It causes the value to come down. That matter ends in that the regulations expire or are repealed, but the economic hit on the premises from having been under the regulations lingers for a while afterwards. Is that sort of lingering valuation impact a matter which can be reflected going forward or not? Do you have any thoughts on that?
I think it's a really interesting point, actually, isn't it? Because I mean, quite clearly, we know that this whole of this coronavirus crisis is going to have a massive economic effect beyond the direct effect of each of the restrictions in a particular situation. So it's going to. So, for example, if the new revaluation had a AVD of 2020, March 2020, if it was changed to that, as opposed to what it is now, which is March 2000, it's still April 2019, isn't it, rather than April 2020 for the new reval. I mean, that would clearly be so vastly different in terms of the economic effects of the AVD. Now, I think the danger of kind of relying on an MCC to then bring in potentially that lingering economic effects gets into the danger of translating sort of AVD type issues into being able to change the AVD type issues beyond what's really permissible when looking at the material day factors. So I mean, I think it slightly depends on how directly related and how narrowly related the economic effect is to the material change you're relying on. If it's just a general, everything's fallen apart, then I think that's going to be a step too far. I'm going to be pushing your luck a little bit. But I mean, that's my sort of initial feeling, without being any more specific. What do you think?
I largely agree with that. It seems to me that if the physical matter ends, so that the physical enjoyment of the property reverts to what it used to be, then any lingering valuation effect is likely to be a matter which is outside the scope of the material day factors for the reasons you explained. So I agree with you on that, Jenny.
Yeah.
I think we've got time for two more. There are two nice short ones which I'll take and draw us to a close. The first is about a proposal where you've got two grounds as an internal MCC and an external MCC. You put your proposal in 16 months after the check, so you rely on the extended external MCC time limit. But it turns out later on that the internal one is value significant and the external one isn't. What does that do to the validity of your proposal? And I think this highlights a really interesting point about Regulation 6A, which is that it allows you to make multiple MCC grounds on one proposal following a check, but it doesn't compel you to do so. If you can always choose to make two proposals, raising the two different MCCs off the back of the single check. You'd have to get the internal one within the 4 months and the external one later. But by separating the proposals in that way, you've insulated yourself from any danger to the validity of a single joint proposal, which might arise if the situation the questioner arises. You know, you don't want to find yourself in a position where you've taken a time limit, an extended time period, such that the tribunal treats the external MCC as the relevant one for gateway purposes, but then it doesn't get through the gateway because it's not value significant. There was a fairly recent case called Jackson and Patel in which the upper tribunal touches on this issue. They say, you know, it's got to be the proposal relevant MCC that is value significant. The fact that the single unified valuation put in other factors can't save your proposal if you haven't identified a value significant one and got it in time. So I think that's a really interesting question for highlighting some of the risks which can arise there. Final.
I mean, I think the answer.
Yeah. Sorry, Jenny, go on.
Sorry, just to say, I was just going to say, I think the answer to that question then is really that you would be invalid, wouldn't you? And that your proposal would most likely be invalid in that situation.
I think there's a real risk.
But in your sort of hedging point, where if you do a proposal on internal within the 4 months, then you also do a proposal on external within the 16 months. Could you, if you just don't have enough time to get all your evidence together in the 4 months as much as you could you shove in evidence relating to internal? There'd be nothing to stop you just shoving in evidence relating to internal also on the back of your external proposal, so that you've got the evidence there when you come to, if you are then lucky enough for the external one to be valid, and then that one can pull in the internal one. Do you see what I mean? And you've got the evidence there. Then it's giving you time.
That raises a really interesting point, which is, of course, in the VTE under the CCA regulations, the only evidence you're allowed is evidence which goes in at challenge stage. Yeah. So if you think there are going to be other MCCs at the material day that you weren't pulled into the global valuation, you've got to get material into that at the challenge stage. The final question we'll take before we draw to a close is this.
Oh, could someone just mute us? Thank you. Yeah.
Oh, lovely. Cheers. The final question we'll deal with is this. On retail, hotel and leisure properties, could the VO argue that the 2020-2021 rates holiday should be taken into account in the valuation? It seems to me that can be dealt with fairly shortly, and that the answer to that is probably not. The rates holiday isn't itself a matter affecting physical enjoyment of the hereditament. The rates holiday is given precisely because something else has affected the physical enjoyment, namely the closure of the property under the more restrictive provisions of the coronavirus regulations that relate to those classes of property. It's not therefore an MCC in that sense. Doesn't affect the modal category of occupation. It's not something which is physically manifest in the locality, and it's got nothing to do with how anything else in the area is used. In that sense, going back to Schedule 6, as we must do as our touchstone for valuation, it's not a factor which falls within any of the paragraph 2.7 considerations. Therefore, it's not a factor which can be taken at the material day. The question then would be, does that factor exist at the AVD? And on the 1st of April 2015, a rate holiday for 2020-2021 not only didn't exist, but I don't think any of us in our wildest dreams would have envisaged it either, because the current situation is so unprecedented and surprising. So for those reasons, it seems to me that the rates holiday is going to be almost entirely irrelevant to 2017 list valuations. One place where you may need to bear it slightly in mind is if you're doing an R&E valuation for the new list, the 2022 list. As we know, R&E valuations reflect rates as one of the expenditure items. And it's something that's going to have to be thought about quite carefully if you're doing an R&E valuation looking at accounts, whether or not a rates holiday is a matter which ought properly to be taken into account when you're doing so. Seems to me probably not, as long as the AVD remains 1419 for the new list. If when the 2022 list comes in, the AVD is scheduled to be the 1st of April of this year, the position might be different. I don't want to say too much about that because it's very contingent on future events, but it's just something that occurs to me that you might want to bear in mind. And with that said, I'm going to draw the session to a close. Thank you very much from me and Jenny and all of us at Landmark to everyone for coming along to the session. Really hope you've enjoyed it and you found it helpful. By registering, you put your email address into our system. If you'd like to be kept informed about any future events, do let us know. Keep an eye on LinkedIn and on Chambers profiles and all the rest of it. And if we do anything like this in future, if we put any further material out, we'll be sure to let you know. And I very much hope that we'll be able to see you all again in future, if not in reality, then on Zoom. Thanks very much, everyone, and have a good evening.
Thanks, everyone.